Good morning, everybody. Thank you first and foremost so much for joining us. Thank you for everybody coming in person, everybody on Zoom this morning. We are so excited to have you attend the Federal Vaccine Mandate seminar, What Employers Need to Know. Before we get started, and I cannot forego saying thank you to all of our partners this morning, the team at Connell Insurance, the team at Missouri SBDC, at Missouri State, MSU, the E-Factory for allowing us to host in this beautiful venue. This venue actually just opened up a few months ago. So thank you to the E-Factory. And then lastly, thank you to Neale and Newman for presenting this content today. A few housekeeping items. Restrooms are located on the first floor. When you go down the first floor, the restrooms are in the center of the building. Of course, we have refreshments right there for you as well. And we will do a break at 9:30 today for 15 minutes. Then we will resume and finish up around 11 or a little bit early. Lastly, for everybody on Zoom and everybody in person, we will take questions at the end. So please jot down your questions throughout the seminar. So I had to tell a little story. When I asked around the community who would be the best person to be able to deliver this content on something that may or may not happen, but something that we all need to know about, I got probably 10 responses that it's Daniel Wooten. So then I called him and he was generous enough to be here this morning. So I'm very proud to and honored to introduce our speaker this morning. Daniel K. Wooten received his undergraduate degree from the University of Arkansas at Fayetteville, Arkansas in 1993. He graduated cum laude from Washington and Lee University School of Law in 1996 and associated with the firm Neale and Newman upon graduation. He has been a partner since 2002. His practice emphasizes employment law, education law, and probate and trust litigation. He is the chair of the Employment Law Division of Neale and Newman and lectures widely on the topic of employment law. In addition to his work at Neale and Newman, his professional associations and memberships include the American Bar Association, Labor and Employment Section, Springfield Metropolitan Bar Association, the Arkansas Bar Association, and the Missouri Bar Association. He was awarded Springfield Business Journal's 40 Under 40 in 2003, and his civic involvement in this community is Board for Leadership Springfield, former board member, Habitat for Humanity, Leadership Springfield again, Rotary Club of Springfield Southeast, Springfield Regional Arts Council, Springfield's Best, and finally, Cub Scouts of America. So please help me welcome Mr. Daniel Wooten.
Thank you. For those of you that are here in person, I just want you to know that I do not have COVID. I sound terrible today. I've been fully vaccinated. I did get a negative test last week. I recently sent my youngest son to the University of Missouri, and in doing that, I lost the person who mulched my leaves every fall in my yard. So I discovered that a 50-year-old should not be mulching leaves. So I sound terrible, but for those of you here, I will promise I will not get you sick. I've been practicing law since 1996, and I have to say, and I've given a number of seminars on topics like changes to the Missouri Human Rights Act or changes to the law, sexual harassment. And I have to say, I don't think I've ever been more concerned about delivering information on a topic than today. And we are here today to talk about the Executive Order 14042 and the OSHA Emergency Temporary Standard, which I will refer to as the ETS. And why would I tell you that I've got concern about delivering this subject matter? There's a couple of reasons for that. One, both the executive order and the ETS were put together rather quickly, and one might even say haphazardly. It's certainly, that would be the executive order and the task force recommendations that follow that executive order. Second, the second reason for that is we are dealing with truly moving targets. A lot of these issues were vague, amorphous, and there's a question whether or not the executive order, and certainly that the ETS will ever even go into effect. So it is a strange seminar where I have to begin by talking about litigation filed in various places in the United States trying to strike the the executive order and the ETS down, but I'm going to give you a summary to begin with of the current pending litigation nationwide as of 9 a.m. yesterday. 9 a.m. yesterday. That would not include things that will be done today, which could very well be new cases filed today. First, I'm going to talk about the litigation affecting the executive order 14042, and this is the executive order that would mandate clauses in federal contractors' contracts. It meant the vaccine mandate executive order. The first case. Before we do that, I always have to. There you go. All right, help me out here. It was just working. All right. I can. You may mention that we're dealing with a moving target, so I always start with this disclaimer. I'm going to present you with general information. I'll do the best that I can, but for those of you who work with counsel and you're especially dealing with human resource issues, as you know, lawyers will typically take a very specific factual scenario, analyze the law, and come to a conclusion. And unfortunately, in your businesses, I assume a lot of you are human resource managers. As you come upon these particular HR issues, I think you could be dealing with vastly different outcomes depending upon the specific facts and the current state of the law, which again could change daily. So let's get to the first case I want to talk about is Kentucky v. Biden. It's not on this outline. Again, this is very recent. It is an order that came down on November 30, 2021. November 30, 2021. Okay, Kentucky v. Biden. And this case was brought involving Executive Order 14042. And what the decision did was it enjoined the enforcement, well, it enjoined Executive Order 14042 from going into effect in the states of Kentucky, Ohio, and Tennessee. So as of November 30, 2021, 3 days ago, there is an order in effect enjoining this executive order from going into effect in the states of Kentucky, Ohio, and Tennessee. Next case, Hollis Plaintiffs v. Joe Biden. Joe Biden is a very popular defendant in the federal court system. Again, this case dealt with Executive Order 14042. And it was interestingly, are there any university people here, school, college people? I thought I saw some from MSU. Interesting, this was brought by, employees of Mississippi State University to keep the executive order from going into effect or being enforced. And the court actually threw the case out. And they threw it out not on what we would lawyers call a substantive ground, but on a procedural ground that the plaintiffs did not have what we call standing. Standing is a technical word, meaning that the plaintiffs could not prove that they would actually be affected by this executive order. They couldn't point to a specific contract over $250,000. They couldn't point to a particular research grant that would trigger the executive order. And so the court threw it out saying you don't have standing. So that case is gone. It was thrown out November the 23rd, 2021. Can you all hear me okay? All right. Case number 3, Smith v. Biden. This is a New Jersey case, again, trying to keep Executive Order 14042 from going into effect. And that case was thrown out, again, on procedural grounds, that they lack jurisdiction over the contractor. Next case. Several lawsuits. I do not have the name of the plaintiff, but there is a joint lawsuit that was filed on October 29 by the states of Alabama, Georgia, Idaho, Kansas, South Carolina, Utah, and West Virginia in the District Court of the Southern District of Georgia.
concerning Executive Order 14042. They're seeking, the states are seeking a preliminary injunction, and it is set for hearing today, December the 3rd. So we'll see what happens with that. Arizona, there's an Arizona lawsuit against Joe Biden, and it was filed, on November 10th, the court denied the state's request for a temporary restraining order, so the plaintiffs lost. Florida, on October 20th, Florida filed a suit seeking a preliminary injunction against the executive order, and it is set for hearing on December 7th. So yet another one. That is U.S. Freedom's Flyers v. Biden. In addition to that, there's a D.C. lawsuit in Washington, D.C., Payne v. Biden, and it was filed November the 22nd, very recent, so there's no hearing set on that case, which I assume is another preliminary injunction case. And then finally, we have the Texas lawsuit. On October 29, the Texas Attorney General filed a lawsuit challenging Executive Order 14042, and it does not appear that it is yet set for hearing. So, ladies and gentlemen, that is my best work here to try to give you a summary of the legal landscape affecting the executive order, at least as of 9 a.m. yesterday. We'll probably have more suits. I would not be surprised if Missouri, the Attorney General filed a suit, especially following the injunction impacting Kentucky and Ohio and Tennessee very soon. But what about the OSHA ETS vaccine mandate? As you probably know, there was a case involving the Fifth Circuit, and the Fifth Circuit has entered a stay prohibiting the enforcement and implementation of the OSHA ETS. Unlike the other cases I spoke to you about dealing with the executive order, this particular ruling has a nationwide effect, and it is still being litigated. And in fact, there's briefing. In fact, the replies to the legal briefs have to be submitted no later than December the 10th. And as you probably know, that is coming after some of the deadlines that was in the OSHA ETS. I'm going to talk a little bit more about this decision, but the circuit was extremely negative toward that ETS. I mean, pretty vicious toward it. It would surprise me if something changes with regard to the enforcement of the OSHA ETS. With all that being said, the way things stand today is that, at least in Missouri, the OSHA ETS is not going to go to effect unless a court does something different. Regarding the executive order, it appears to me like it's going forward in the state of Missouri as of this morning. Again, that could change. But to begin with, I'm going to start talking about the ETS. I'm going to cover some of the highlights of that OSHA ETS. And then in the second part, dealing with the executive order, I'm going to go more in depth than I am with the ETS, simply because, again, looking at the situation today, I don't know if this ETS is ever going to happen. As far as questions are concerned, I would prefer to get to the end of the seminar before we field questions, so be thinking about your questions. And at the end, I'll do my very best to answer those questions. Okay, let's get started. Okay, again, we're talking about the ETS, the OSHA ETS, and who does it apply to? According to the ETS, it applies to all employers with a total of 100 or more employees at any time it is in effect. And it would pull employees from all across the country. So you do not look at a particular work site like you would with the FMLA or something like that. You look at total employees. If you've got a number of stores dispersed throughout the country, you look at the total employee count. It includes part-timers. And the key date they look at is November 5th, 2021. If you had fewer than 100 employees on that date, then it would not apply to them. But if any point in time during the term of the ETS, which I find humorous since we now have a court order enjoining it, is it in effect? Will it go into effect? But let's engage in the fantasy world for a moment that the ETS does go into effect and you don't have 100 employees on November the 5th, but subsequently during the term of that ETS, you did hit the 100 employee threshold. Then at that point, the ETS would apply to you. Okay. But once, let's assume you hit the 100 threshold and you drop below 100, you hit 101, then you go down to 99. It's my understanding that that ETS will continue to apply to you based upon the threshold. So that is how you know if the ETS would apply to you, assuming it ever becomes alive. Now, what the ETS is quite a bit different than the executive order. The ETS actually gives you two options. You have the mandatory vaccination policy and the mask and test requirement. Two options. So let's talk about the mandatory vaccination policy. A mandatory vaccination policy is an employee policy requiring each employee to be vaccinated. Okay, so that's option number one. The policy, if you go that route, the vaccination mandate, it has to apply to all employees except a certain limited subset. First, it would be for those that medically they just can't get it. There are some people that have reactions to inoculations, and you could get proof of that. It's a very small subset of people, but they are out there. And for those who may be medically necessary for them to have a delay in vaccination, maybe they've been sick or something, the doctor says, hey, you need to get it, but you need to wait a week or something like that. Interestingly, I did not see pregnancy as a reason for that, but something to think about. And finally, those who are legally entitled to a reasonable accommodation on account of a disability or a sincerely held religious belief. And I know that that third bullet point there is a point of concern. It will probably be what I'm going to be fielding questions on for the next 6 months. Thank you, Joe Biden. No, just kidding. But I am going to go over that and give a little bit of information to the best I can. Okay, mask and test requirement. In lieu of imposing option number 2, in lieu of imposing a mandatory vaccination policy, the employer can establish and enforce a written policy allowing an employee not subject to the policy to choose either to be fully vaccinated or to provide proof of regular testing and wear a face mask. Okay, so 2 options. You can go the testing and face mask. And it does appear that the ETS would allow you to have these 2 different ways of approaching this ETS, dealing with different aspects of the workforce. Let's assume that, you're a retail store and you've got retail stores where patrons come in, but then you have like an office where there's people that, have employees that don't really face customers. The way I look at this ETS, that would give you the option to maybe handle the places differently under the concept that the people in the retail stores are dealing with people and maybe they need to be vaccinated, and maybe the people in your office who have offices, going all the way to the ceiling and can socially distance and bring their own food and all that, maybe they don't need to be vaccinated. So I think the ETS, unlike the executive order, would give you some options. I am not doing a very good job of going through this. My apologies, but that's what I was reading from previously. Okay, what about the employer requirements? Employer requirements. We've already talked about some of them. So you've decided to go, you're an employer, and you've decided to go the vaccine mandate route. Okay, either with part or the entirety of your workforce. In other words, you're going to make your people get vaccinated or do something to them, theoretically. So what you've decided on that option, what do you have to do here? The employer must require each vaccinated employee to provide acceptable proof of vaccination status, including whether they are fully or partially vaccinated. And that term fully or partially vaccinated is in fact a term of art that we can talk about later if you have questions about it. It's actually covered later in my outline. So you have to maintain proof of that. And the employer must maintain a record of each employee's vaccination status and must preserve acceptable proof of vaccination for each employee who is fully or partially vaccinated. This roster that you keep must list all employees and clearly indicate for each one whether they are fully vaccinated, again, partially vaccinated, not fully vaccinated because of medical or religious accommodations. So in other words, if you mandate a vaccination and the employee comes, hey, I've got this religious belief, insert religion, and therefore I can't get vaccinated. And you go through the interactive process, and yes, you will go through the interactive process. You have to document what you did with that person, that decision. And if not fully vaccinated because they have not provided acceptable proof of vaccination status. Now, I could go into detail. There's there's a lot of detail of what that documentation looks like. I don't have this in my outline. I have it here and I could give it to you. Again, I don't know how much detail you want concerning an ETS that a court has enjoined going into effect. But I will just say this, you can use a vaccine card. That's always good. Unlike the executive order, the ETS does allow, if you're an employer and you've tried to get the card from the employee and maybe they have a good excuse, maybe the dog ate it or something like that, and you can't get a record, the ETS does contemplate the employee. Again, we're talking about the ETS, not the executive order. Does contemplate the employee being able to give an attestation, not almost like an affidavit. It actually, there's a very specific language they have to do, so the employee could give an attestation that yes, I have been fully vaccinated. And fully vaccinated incidentally means 2 weeks after the second dose. That's what fully vaccinated means, or 2 weeks after the one dose if it's is it Johnson & Johnson? Is that it? Yeah, that's fully vaccinated. Okay. Okay. Time off for vaccination and recovery from side effects. Again, this is the ETS. The employer must provide a reasonable amount of time for each employee to get each of their primary doses. Okay. Again, for primary doses of talking about the Moderna and Pfizer. And as an employer, you have to provide up to 4 hours of paid time, including travel time, if the employer is regular to pay for this purpose to go get these doses, the vaccines. One important part of this is that the employer may not require employees to use their personal or sick time to get vaccinated. So the way I understand this, again, assuming this applied to anyone, that this creates a special 4 hours of paid leave, the way I construe it, where employees can go get that. You can't make them use their accrued PTO. Most people have PTO these days, paid time off, where they combine vacation and sick leave. What about though the employees get ill? As you know, sometimes people have reactions to the vaccine, and it does provide that if the employee already has accrued paid sick leave, an employer may require the employee to use their paid sick leave. In other words, you have to give them leave to recover from the side effects. We're talking about paid leave. Where I said you had the additional 4 hours of paid leave, that applied to leaving and getting the vaccine. But let's assume they get sick, and these are normally temporary situations. You need to let them recover from that. But what they're saying is that you as an employer, and you probably really should put this in writing if you're going to do it, you could mandate that they use their accrued paid sick leave. This is similar to the concept under the FMLA, where you can have mandate in the policy that accrued leave run concurrently with unpaid leave. You know that? Yeah, similar to that. But what you can't do is make them use advanced sick leave, because most of you have these policies, your HR people, sick, PTO, and a big deal is how you accrue leave, right? I mean, how do you accrue it? Is it by month? Is it yearly? Is it up front? Is it front loaded? I mean, most policies are becoming front loaded. But let's assume that the next week you have someone that takes off 6 hours, and the next day they will have accrued 6 hours of paid leave, but it hasn't accrued yet. I'll just make you take this 6 hours that hasn't accrued left. I don't think you can do that under this OSHA Act. Does everyone understand that? Okay, the difference? Okay. All right. Enforcement. OSHA enforcement efforts will be primarily based on employee complaints, is my understanding. And, OSHA, they have complaints. And a lot of times what I've seen them do, if they get a complaint, and, sometimes OSHA will send a letter out and give you a deadline to respond. And they say, if you respond by a certain deadline, and if we're happy with it, we won't personally come in and visit you. And I assume that's what they're going to do in some cases, if maybe they think it's minor, or maybe the employer just hasn't quite gotten its act together. Again, that's my assumption. And again, this is all of assumptions again, because we don't know if it's even going to effect. But sometimes I've seen that. In fact, recently I had a client that had a complaint which was pretty specious, and that letter came in, and I responded, and OSHA did not act on it. They accepted my letter. But OSHA will, however, be having some programmed or planned inspections where OSHA goes to workplaces to ensure compliance. And, they can do that without it, without giving you a chance to respond. They can just show up, which is always interesting. So let's assume something bad happens. Let's assume that the Fifth or Sixth Circuit, or whatever circuit it is, undoes the order, or the Supreme Court, which the Supreme Court will eventually get this, and it goes into effect, and you mess up, your company messes up. What are the fines for noncompliance? And I'm taking this is directly from the website. I mean, this is directly from the website. So we have other than serious posting requirements. Penalty $13,653 per violation. Failure to abate is there. And willful or repeated, it can get pretty costly. So those would be the fines for noncompliance. All right. Good faith efforts to implement. So you get a complaint or a letter, and then an investigation, and there's a problem at your workplace. OSHA will exercise enforcement discretion to forego programmed inspections where employers have made a good faith effort to implement a mandatory vaccination policy and have reached fully vaccinated status for the mass majority of covered employees at a particular work site. So that says programmed inspections. And I don't know if that is also dealing with potential inspections from complaints. My assumption is that it would be. Again, I mentioned before that sometimes OSHA will send a letter saying we've had this complaint. Here's A, B, C, D. What's your response? Get us a response in a week. And I'm assuming that if you give them a satisfactory response, they would not move forward with an actual in-person inspection. But it's a little unclear to me, to be frank about it. So when determining an employer's good faith efforts to vaccinate their entire workforce, OSHA will consider the extent of the workforce that is fully vaccinated and the steps the employer has taken to protect unvaccinated workers. So it will be a very factually specific inquiry, apparently, to determine whether the OSHA will give leniency for minor violations. For example, discretion would be appropriate, for example, where work sites where almost all workers are vaccinated, approximately 95%, and the remaining unvaccinated workers have limited to no contact with others. In that case, the OSHA says we might cut you some slack. What about work sites with only a small portion of the unvaccinated workers and those who are unvaccinated have had the first dose and are scheduled to receive the final dose? In other words, they just didn't quite meet the final dosing requirement in time. Again, completely vaccinated is 2 weeks after the second dose, just a little late. And establishments with high turnover rates and where consistent efforts are made to ensure that new employees are promptly incorporated into the employer's vaccination policy. Some employers just have high turnover. It's going to be particularly difficult for those employers to comply with this. And I've already covered this, but I want to a little bit. But before I leave this topic, toward the end, I do want to go back over the Fifth Circuit's decision and tell you why I believe it's unlikely that. This is Danny Wooten's personal belief, and tomorrow I could get back to the office and read a newspaper or an order that says, "Hey, the court has reversed its ruling and the ETS is going to effect." But the Fifth Circuit was extremely critical of this ETS. The language, the mandate is a one-size-fits-all sledgehammer that makes hardly any attempt to account for differences in workplaces and workers and have more than a little bearing on workers' varying degree of susceptibility to the supposedly grave danger the mandate purports to address. That is not a court that's happy with a mandate. Further, the court said OSHA's assessment of scientifically complex facts and its balancing of the competing policies that underlie the decision whether to issue an ETS are entitled to great deference. And what the court is saying here, when you have these administrative agencies, in fact, law school, we have to take like an entire class on administrative law. It is riveting. I mean, it is so exciting to learn about agencies. But at a base level with agencies, when agencies do things, they have to go through a process. Rulemaking or anything like that. And there's a very particular process. And when they go through those processes, and sometimes they have to get comments from the public. And if they do that, in courts evaluate what agencies do, they give deference, discretion. They say, well, we might have come to a different result, but hey, we're going to give deference to the agency because they're experts. We're a court. We don't know about occupational safety. They went through all the steps that they're supposed to go through. We're going to give them the benefit of the doubt. The court is saying we're not going to give them the benefit of the doubt. They may be, we're supposed to give them deference, but this was, the basis for this just didn't make sense. So this is an unusual approach to agency action from a court. Evidently, the Sixth Circuit is looking at this now. So the Sixth Circuit can either lift or modify the stay and allow implementation enforcement pending the outcome of the case, or deny the United States request to lift the stay. Either way, it's probably going to get to be to the highest court of the land. So what should you do? What should you do? Well, if this if you have over the 100 employees and this ETS could possibly impact you, what do you do? Well, the simple answer is you need to ask your lawyer what to do and get advice on what to do in that situation. A lot of people, our clients are getting prepared to comply with this order and just waiting to see what happens with the court proceedings. So that is it for my outline on the OSHA standard. And I know that 9:30, again, I went through this pretty quickly. The outline on the executive order is much more robust, simple because I'm not aware of any court action in Missouri that says that it's not going to go in effect like the ETS, which as of today will never see the light of day. But why don't we do this? I will open it up for questions on the ETS, and I will do my best to answer your questions concerning the ETS. But why don't, Chase, why don't we do that to begin with, and then we'll take a break and come back and talk about the executive order. So that being said, is there anyone in the audience that one moment. Okay, I have my OSHA ETS cheat sheet in front of me. Hopefully the question that you have is on my cheat sheet, but what is your question? The question was, I think what you're doing is contemplating having vaccines given on site. And if the 4 hours would still apply leave. And guys, I hate it that I'm, as a lawyer, I have to equivocate and always give disclaimers, but I just have to do that, okay? I think you should talk specifically to your lawyer. My feeling on it would be due to the fact that the ETS is skewed. I mean, obviously it wants to promote vaccinations. It's designed to promote employees to get vaccinated. I would think that to the extent that it would be leave, I guess my question would be, why would there be a need for leave if they're getting vaccinated? I mean, are they literally working from their office, getting a shot, then going back to their offices? My initial reaction again would be offer it. But if someone says, hey, I want to go to CVS and get the vaccine, I would feel very uncomfortable about telling my client to take disciplinary action against that employee for leave. I would feel uncomfortable giving that advice without definitive rulings. But there are lawyers out there much bolder than me on their advice. Any other questions?
So if you have an employee who voluntarily goes, let's say they work Monday through Friday and they voluntarily go to get their vaccine on a Saturday or a Sunday, do you have to reimburse them for that time?
You know, I'm going to say I don't know for sure. That's something I would need to look at specifically. The ETS, as I understand, contemplates someone going during normal work hours. Paid leave is my understanding. So I wouldn't think so, but that is one of those where if the call came out, I'd want to look specifically at the language. So yes, I'm going to not directly answer that question. Definitely. Any other questions? Yes. You in the red.
You made comment that you had the religious form. Were you gonna make that available to us?
Pardon me?
You had the religious form for the employees to fill out if they didn't want to get the mandate. Did you say you had that form
Religious form?
for exemptions?
I didn't remember saying that. No.
Oh.
Okay. I'm sorry, Chase, I
Oh,
cannot hear
sorry.
you.
The spreadsheet for the name, if they have the vaccination, are they partially vaccinated or is it no vaccination due to religion or medical?
Oh, yeah, I mean, you have to keep that record. Is that your question? Okay. I do not have that form. Yeah. So, any other questions? You know, who knows what OSHA would do, but the ETS does contemplate the concept of accommodations for disabilities and sincerely held religious beliefs. And my thought would be that if you went through the interactive process and you documented and you came to a reasonable conclusion, one would hope that OSHA would give leniency using the standards that we went over earlier. Remember the enforcement discretion not to do something. So when you ask me, would they not do something to me? I can't answer that question. One would hope that if you go through the proper steps and you came to a reasonable conclusion, for example, well, you know, they could do telework and I sent them home to do telework or something like that. One would hope that OSHA would be kind. Any other questions? All right. So I only evaded one question directly, but not answer. That's pretty good for a lawyer. It is. All right. Why don't we go ahead and take a, I'm done with, it'll probably be, let's do this. I know this is a little bit, we're 15 minutes early. Can we maybe come back like at 9:35, 15, 20 minutes? Will that work? Chase?
Yes.
Okay, 9:30, 9:35, and we'll cover the last part. Again, it's going to be more involved.
Good afternoon, everybody. Thank you guys again for being here today. We are going to go ahead and get started from break. A few housekeeping items before we get started. Number one, there is a evaluation form on the desk. If you could just fill that out before you leave today, that would be great. As well, the refreshments will be available for the rest of the seminar too. So without further ado, I will hand it back over to Mr. Daniel Wooten for the second part of our presentation today.
Okay, thank you. There are a number, I think there are some people viewing this remotely, and I want to apologize for not giving them the opportunity to ask questions. So before I begin talking about Executive Order 14042, are there any questions concerning the temporary standard from those who are attending the seminar remotely? And I believe they can answer those questions through a chat function. In chat, no questions? Okay. Okay, we will now begin talking about Executive Order 14042. Executive Order 14042. Under this executive order, executive departments and agencies are required to ensure that contracts and contract-like documents, another vague term that lawyers love, covered by the order include a clause requiring contractors and their subcontractors at any tier to comply with all guidance for contractor or subcontractor workplace locations published by the Safer Workforce Task Force. Okay? Covered employees must be fully vaccinated by January 18, 2022. unless a covered contractor is obligated to provide an accommodation for a disability or sincerely held religious belief or practice. Now, we're going to go into a great deal of detail on what all this means later on. I've got several pages here, but let's just stop for a moment. What is this saying? This is saying that if you have a government contract, and we're going to talk about the thresholds in a minute, at a certain point in time, you have those contracts, there has to be a clause requiring that the contractor and the lower tier subcontractors in that contract be vaccinated, that the working in or in connection with the contract will be vaccinated. There's a deadline, and that deadline is January 18, 2022. And that is significant if you do the math, and it's my understanding the definition of fully vaccinated in the order is very similar to, if not exactly the same as the ETS. If you run the math back, then I think that's January 4, I believe, you have to get your second shot if you're a Moderna or a Pfizer person, or your single shot. So if you're doing the 2-shot regimen, if you think about it, that would mean that you'd have to be having a shot real soon now to comply with this contract, or excuse me, with this executive order. So again, I've already told you about preview this page here, but again, fully vaccinated means 2 weeks after receiving the second dose. And it must be a vaccine currently approved or authorized by the FDA. And again, I think we're just talking about 3 options. Again, the Pfizer, Moderna, and the Johnson & Johnson. Okay, let's talk about this. Let's dig into the requirements a little bit more. Okay, so you are a covered contractor or subcontractor. Covered contractors must ensure that all covered contractor employees are fully vaccinated for COVID-19 unless the employee is legally entitled to an accommodation. That's it. After January 18, all covered contractor employees must be fully vaccinated by the first day of the period of performance on a newly awarded covered contract, or by the first day of the period of performance on an exercised option or extended or renewed contract when the clause has been incorporated into the covered contract. So if you got a contract on January 18, a new one just a few days before, if it's been renewed recently, it's got to have the clause, and you're going to, all covered workers on that contract have to be vaccinated. Okay, that's the vaccine. That's the vaccination part of it. There is also and I'm not going to spend a whole lot of time on this. There's also a masking and social distancing aspect to the executive order. Okay, so we got the mandatory vaccine, and then we have the masking and social distancing. So in addition to the mandatory vaccination in areas of high or substantial COVID-19 transmissions, fully vaccinated people will sometimes need to wear a mask in public indoor settings, except for limited exceptions. And they are when an individual is alone in an office with floor-to-ceiling walls and a closed door. So if you have, I guess if you have a 6-inch space at the top of the wall, that's not good enough. It's not good enough. Okay. And for a limited time when eating or drinking and maintaining social distancing. You don't have to. And while outdoors, you don't have to, but they recommend wearing a mask if it's a credit outdoor setting, maybe a garden party or something, I don't know. But those are the exceptions. Now, so that's high or substantial COVID-19 transmission areas. In areas of low or moderate transmissions, fully vaccinated individuals do not need to wear a mask or physically distance in federal buildings or on federal lands, except where called for by federal, state, local, tribal, or territorial law, rules, and regulations. Fully vaccinated individuals do not need to physically distance regardless of the level of transmission in the area in the low to moderate transmission settings. Okay. Now, that brings the question, how do we determine our level of transmission? There evidently is a portal. I've not looked at it, but I understand there's a website, a covered contractors. You have to check a CDC COVID-19 data tracker, County View website. Has anyone looked at this? Anybody? Okay, evidently it's out there. But you can look and it tells you what level of transmission that you have. And all areas where they have a covered contractor workplace. So you have to go on, check where you have a covered contractor workplace to see what level you're at to determine whether or not you have to do the masking and spacing. Okay. And again, when the level of community transmission, the area of the covered contractor workplace increases from low to moderate to substantial or high, then you would then have to use the more robust protections with the masking and spacing. When the level of the community transmission, the area of the covered contractor workplace is reduced from high to moderate, you must continue to do the more robust distancing and masking until there's been a 2-week period of time where you've reached that substantial or moderate level. So it's a period of transmission. Okay. COVID-19 workplace safety events coordinator. So you have the mandate. How do you track this? A covered contractor must designate a person or a person's designee to coordinate implementation of in compliance with the guidance in the workplace safety protocols. There was a similar concept in the ETS. The person that the contractor designates may be the same person for implementing additional COVID-19 workplace safety protocols required by other laws, such as the ETS, if it had in fact gone into effect, or state laws. There are some states that have enacted vaccine mandates. Okay, so you got to have a coordinator. The coordinator must ensure that all the information required on COVID workplace safety protocols is provided to the covered contractor employees and all other individuals like to be present. What does this include? This would include communicating the required safety protocols via email, websites, flyers, writings, however you want to do it to get the information to the workforce. And also communicating the safety protocols and requirements related to the masking and social distancing. So again, you've got the coordinator that's coordinating, making sure that the information gets to the employees of the contract related to the mandate and also to the social distancing and the masking. That is part of the job of the coordinator. In addition, the coordinator must ensure that the employees comply with the requirements of the guidance, which includes documentation. Okay. And we'll come back. That's a teaser for what the documentation is going to look like. But let's talk a little bit about covered contracts. A covered contract is any contract or contract-like document. Okay, contract-like document. I love that. So if you've got a contract, if you're an executive department, if you have a contract or a contract-like document, instrument, you must include a clause and it has to be incorporated into lower tier subcontractors. So you've got the contract, you're going to have subcontractors too. This clause shall specify that the contractor or subcontractor shall, for the duration of the contract, comply with all guidance for contractor or subcontractor workplace locations published by the Safer Federal Workforce Task Force. This task force they're referring to was the task force that was put together to effectuate the executive order. They're the one that put forth the guidelines. So all this is saying is that for the duration of a contractor, the contractor and the subcontractor have to have the clause in it mandating the vaccinations. Has to be present in the contract or you'll be in violation. Okay, the guidance from the task force, again, this is the task force that was tasked with enacting Biden's executive order. It will apply to a contract-like document if it is a procurement contract or contract-like for services, construction, or a leasehold interest in property. Okay. There's some specific limitations for the DOL. Also, I believe there is related to federal property or lands and certain purchase orders. It does not, what does it not, I think it's more helpful to talk about what it does not apply to. Grants. Now that's a really big exception, grants. What? Huge. And that's probably the biggest exception, does not apply to grants. There's some limitations to Indian tribes. I'm not an expert in that, but as you probably know, our government has a number of agreements with the Bureau, particularly the Bureau of Indian Affairs has a number of agreements with tribes. I only know that because my brother works for the Bureau of Indian Affairs. But there's also a $250,000 threshold, which is another important threshold. It does not apply to people, to workers outside the United States. They just don't care about you if you're outside the U.S. You're on your own if you're outside the U.S. Another huge limitation does not include contracts or subcontracts solely for the provision of products. So two big exceptions, really, grants and contracts or subcontracts solely for the provision of products. What if the contract involves both the provision of services and products? What if it's some sort of IT contract? And I think my opinion or thought would you have to very closely scrutinize it, because the word solely is put there for a reason. And I mean, if solely means solely, I think it would only have to relate to products. So a lot of times you have these contracts, you have several subcontractors, you get way down to the bottom of the subcontracts, and you will likely have people solely providing products. And I think that's what they're talking about, that it would be those sort of subcontracts that would not be covered. And I will try. Yeah. What is your question? I have no idea. I'd have to really look into that. That is a very specific question on a specific provision dealing with this particular type of contract. I do not believe you have to track the subcontractors, because you have to require, it'll have to be required in their contracts. Do you understand? Yes. Yep. Yep. You know, I would need to look into exactly in the context they're using dependents, their employees, their dependents with respect to that provision. But that's a really good question. Okay, anything else? Okay. Where were we? Hold on. Going backwards. See, this is what happens when you make me go backwards. And it's all right. Okay. Have we covered this screen yet? Okay. Go back one. Okay. Okay, here, provision of products. Again, I think the two big exceptions will be grants or contracts solely for the provision of products. Even if a contract is not a covered contract. So let's assume that you're a contract that does not fall within the thresholds. Maybe it's less than 250,000. Maybe you think it's solely for the provision of products. Just because that happens, don't assume that the executive agency that the contract is under is still not going to require a provision of the contract. Because even though the executive order and the task force guidance as a result of that order, even though it had certain limitations, for example, not applying to products, not applying to grants, these agencies are encouraged to require such a provision even in those contracts that don't fall into those thresholds. You follow me? So don't just assume that if you have a contract under 250 for products, that you're still not going to be required to include such a provision in your contract if you want to do business on that contract, on that prime contract. Okay? All right. And there's some stuff in here about possibly recovering costs due to the mandate. That is a whole probably 30 minutes in and of itself. If you're interested in looking at it, look into that. That's a little bit beyond the scope of what I'm talking about today. But there is some information out there that you might be able to recover some costs on account of the mandate. It is also likely that agencies will be permitted to modify existing contracts and require compliance, even though the contracts were entered before the date that it went into effect. Okay? All right. Okay, let's talk about covered contractors and contractor workplaces. Okay, the order in the guidance from the task force applies to all full-time or part-time employee of a covered contractor working on or in connection with a covered contract or working at a covered contractor workplace. So 3 things, okay? Working on a contract, okay? You can kind of understand that. In connection with a covered contract, if you're supporting a contract, another way to think about it. And finally, working at a covered contractor workplace. Okay, 3 parts, very important. So this definition, or the 3 parts of this definition, would not only include the employees themselves, but also those working connection or supporting. Let's assume that you're not working on a contract, not supporting it, but you walk into a room where there are people, maybe you're an affiliated entity, and you just walk into a workplace where there are other employees who are working on or in connection with. If I understand the scope of this order, if I understand it, that means you are working at a covered contractor workplace. Okay? This is a very broad, just on the plain language, this is a very broad coverage that you need to be aware of. Okay? And let's dig into this a little bit further. Remote employees who work on or in connection with a federal contract are covered by the vaccine mandate. The guidance does not identify what reasonable accommodations an employee may offer to employees to work remotely and request a reasonable accommodation for disability or religious reasons. So the point I'm making here, unlike what we saw earlier, the mandate does apply to people working remotely. Okay. Again, we're talking about the executive order. Okay. Okay. What would be accommodations? What would be some common accommodations that might apply here? Again, like we saw earlier with the ETS, it does contemplate accommodating people with sincerely held religious beliefs and disabilities, although unfortunately very little assistance is given in the order. So common accommodations could include masking, weekly testing, social distancing, remote work, and inability to travel for work to meet with clients. In some instances, circumstances may prevent a reasonable accommodation, such as when providing a reasonable accommodation will prevent an undue hardship on the employer and removal from the workplace may be required. Okay. And I'm going to get more detail this in a minute. For example, if an employee is required to be present at the workplace due to the nature of the work and requests a reasonable accommodation, allowing them to avoid vaccination and also not wear a mask, again, you'd have to go through the interactive process. In that situation, you may have to say, no, I can't work with you. I mean, you know, you're not at home, you're coming in, you're around people. Wearing a mask and not being vaccinated just isn't going to cut it here. Okay. And what is a covered contractor? Again, we talked about this earlier. It would be the prime contractor, any subcontractor flowing all the way down until you get to a contract solely dealing with products. And even if you got down that far where you're dealing only with products, I think you would really need to scrutinize it to determine if there's any aspect of that would require services. Okay, what is a covered contractor workplace? Again, we've got to look at if you're working on a contract, whether you're supporting a contract or if you're dealing with a covered contractor workplace. That would include locations controlled by a covered contractor at which any employee of a covered contractor working on or in connection with a covered contract is likely to be present during the period of performance for a covered contract. Okay? Fortunately, it does not include your residence. Okay? Does not include your residence. Okay. But this only applies to the masking physical distance requirements. So employees working on a covered contract remotely, even if they never work at a covered contractor workplace or federal workplace during the performance of the contract, are covered. All right? So again, very broad coverage. Okay, what would include work performed in connection with a covered contract? And we do have some guidance on this. So some specific examples they give would be employees who perform duties necessary to the performance of, I'm sorry, this is such a dry topic. I feel sorry for you guys out there. This is so boring. I can't help it. I can't make it any better. You know, if you talk about sexual harassment, you can at least tell stories or something but I can't make this any better. Sorry. Just very dry material. Okay. So employees who perform duties necessary to the performance of the covered contract, but who are not engaged in performing the specific work called for the covered contract. For example, and again, we're talking about who would be performing work in connection with the covered contract. It could include such things as human resources, for you human resource people, billing, legal review. I guess that would possibly get in-house counsel, maybe. Yeah. Finance, sales support, and information technology. You know, that comes up. You're talking about third parties that come in. You know, I think there could be an argument made either way. I think the question would be not so much. I don't think it would fit in under here, but the question would be: are they subcontractors or are they consultants? And I was reading some material from a law firm that opined that outside HR consultants and outside lawyers would not be subcontractors, they would be consultants. But I think we were dealing with a gray area. Your opinion, I almost hate to opine, I would almost tend to think no, if it's truly a third party HR, not a W-2 employee, would not be a subcontractor, they would be considered consultants and possibly not fit with that definition. But I think that might be an evolving. This is again my way of a lawyer of equivocating and not really answering your question. I wouldn't think so, but if you're dealing with it, I'd want to see the evolution of how the various the contracting agencies are enforcing those requirements to see maybe they will take the position that it would apply. Okay. All right. All right. What about affiliates? A lot of times you have entities that are related somehow. Maybe they have, did I say something shocking? Okay. Maybe they have common owners calming payroll, or things of that nature? And are the affiliates covered? And I think the thing to look at, if yes, possibly, I think it comes down to, are they working in the same workspace? And would they be covered? And again, the concept of whether affiliates would be brought in, again, is another issue that would take a very, probably beyond the scope of this seminar that's covering the basics of this executive order. But let me just say this: if you're involved in an entity that has affiliates, and if you have workers from affiliates going into the workplace of the other, and you're trying to thread the needle and say that you don't have to comply with this order, I think you need to take, I would just encourage you to really sit down and take a close analysis of that decision-making process on your part, because there's a lot of information and definitions dealing with affiliates and what is a workplace in this order. Okay, I didn't see anyone, I don't remember anyone being from a bank that I saw on the attendee list, but I just find this fascinating on banks and financial institutions. So I'm going to spend a little bit of time talking about it. I assume there's no banks. No. We got one bank. Okay. And I've had this question come up in whether or not banks have to comply with this order. At this time, which surprises me, banking institutions are not automatically subject to the executive order solely based on their FDIC relationship. And according to the Wisconsin Bankers Association, banks that have explicit contracts with the federal government will be covered. If they're on military bases, other federal property, then they would likely be subject to the order. Otherwise, they're not subject to the mandate. Again, this is according to various bankers associations. Also, in why you're saying, Daniel, why do you find this surprising? I don't know. Do any of you have affirmative action plans? No, affirmative action plans. I assume most of you do because you're government contractors, or you wouldn't be here listening to me today. So as you probably know, if you have a government contract at a certain threshold, have 50 or more employees, that one or more executive orders require you to have these wonderful affirmative action plans. Well, banks, almost every bank of any size has to have an affirmative action program if they have $1 of federal money on deposit. It brings the banks in. And so again, I find surprising to me that if banks, virtually every bank in America has to have an affirmative action plan, why would this order not also bring in the same group of people? But according to all of these banking associations that know all about banking law, evidently that is not the case. That just if you have $1 of U.S. money on deposit, which would require you to have an affirmative action plan, you do not have to you're not automatically subject to this executive order. I find that interesting, but banks, if a bank and you don't think this applies to you, I find it shocking that banks do not have to impose this mandate, that it is not subject to them. And I think that very soon we will see the FDIC or something catch this and bring within the scope of this mandate every single bank that has a single dollar of U.S. money on deposit. Okay, colleges and universities. I did see there was one university. I do not believe, although a college or university may not be subject to the EO based upon grants provided by the federal government, some college and universities will be subject to the EO by virtue of any research contract. So this is an important distinction for a lot of times small colleges, universities, they get grants. And that's just where you give money to do something. And this has made a distinction between that. So just having a grant is not going to make you subject to this mandate. But many universities, and my brother works at a medical school and he has to do do these grants, we actually have a contract with an agency like the Department of Homeland Security to get money to do research, like on bad germs and or stuff like that. That would be a contract. That's a research contract. And so if you're a university or a college, I think you really have to look, is this a grant or is this a contract-like document? And I think these sort of research contracts would be, and that would bring the university, or at least the buildings where this contract is occurring, into the scope of this executive order. For example, if one professor has a federal research contract, the entire campus is probably covered, unless they can show that no employee student will come into contact with employees working on that contract. And I would be very fearful as a university if you have one of these research contracts to say that you're not covered, frankly. And why is that? Because the guidance covers lobbies, security clearance, elevators. This is, again, the workplace, covered workplace is a very broad definition. Okay. The universities that cover, the order will cover all full-time and part-time employees, staff, administration, and student workers. ROTC programs. ROTC programs will likely make the university school subject to the executive order. Sitting here today, based upon my reading of everything, I do not believe that the order would apply to a institution of higher learning simply because they're participating in the Pell Grant program. All right. Let's talk about accommodations. Finally, we get to the part of this that everyone wants to hear about. Again, we don't have a lot of information from the agent, from the executive order itself. Let me see how I'm doing on time. We have plenty of time. Okay. There are two scenarios where you do not have to require a covered employee to be fully vaccinated. And that would be where they're entitled to a reasonable accommodation on account of a disability as defined by the ADA and entitled to a reasonable accommodation, or on account where the vaccination conflicts with the worker's sincerely held religious beliefs, practice, or observance. So let's dig into this a little bit more. So you're an HR manager and you're administering this, you have employees that are under this covered contract, and you receive notice that an employee's disability prevents them from being fully vaccinated. What do you do? Now let's back up for a minute. As you all know in HR, when you deal with issues dealing with employees who've requested accommodations either for a disability or a sincerely held religious belief, the initial obligation is they're very similar. You have to engage in what's called the interactive process, right? Interactive process. What is that? That's a give and take situation where you have to explore the request made by the employee. And once that request is made, the law gives you the right to make certain inquiries of the employee that you would not have had the ability to make before. You can ask some questions like, hey, give me a release from your doctor so I can explore this disability that you say prevents you from being fully vaccinated. This gives you the opportunity to say, well, you know, not to get specific, but I've actually had this come up in my practice. So you say, I'm giving you a true example. I'm not picking on any religion, but this has come up, seriously. So you say you're Catholic and your beliefs say you don't have the vaccine. How do you reconcile that with the Pope who says it's okay? Give me a letter from your bishop. I've seen that. So those are the sort of inquiries that can come about. You can make some limited inquiries as part of the interactive process. But the important thing you need to know is that you've got to engage in the interactive process. I've defended a number of ADA cases over, and I know I'm getting off topic on the ADA, not really, but on the ADA, I've defended a number of cases. I'm defending one right now, 3 years into it, and the issue is, did the employer have to engage in the interactive process? Okay, So you need to engage in the interactive process. If you don't, there are some courts that say that's an automatic violation of the ADA if you don't do that. Okay. Some employers have forms. It's called a reasonable accommodation request form where they actually document it. I know I'm beating a dead horse here. Do the interactive process, always. If there is no reasonable accommodation that will allow the employee to comply with the guidance while being physically present to perform his or her current job, the employer must consider if telework is an option or reassignment. Now, I've already covered this, but you can ask for reasonable documentation about concerning the nature of the impairments, the duration or need for the accommodation, and to the extent to which the impairments conflict with the requirements of the guidance. So again, you can make certain limited inquiries. You can even pose questions directly to the physician. Again, I would strongly recommend that you have a written release from the employee. Yeah, okay. Next slide. How do we handle requests for reasonable accommodations due to sincerely held religious belief? Once you're on notice that the employee claims to have a sincerely held religious belief, again, at a minimum, engage in the interactive process and determine if you come to the conclusion that the employee has a sincerely held religious belief, which you almost always do. You have to determine whether or not it would impose an undue hardship. Under Title VII, when I say the definition of undue hardship that you see there, I want to be clear, only relates to a request for an exemption for a religious belief, okay, not disability. So it says it's defined as imposing more than a minimal cost on the employer. Again, that's the standard for undue hardship on the religious side, not disability. It's a much more stringent standard on the employer. If there is no reasonable accommodation that will allow the employee to comply with the guidance while being physically present to perform his or her current job, the employer, again, must consider if telework is an option or if a reassignment to another position is possible. Okay. So you get a request from someone that says that they want to not be vaccinated because of their religious beliefs. Is it a sincerely held religious belief? The definition of religion is very, very broad under the statute. And it would include religions that you may be unfamiliar with. It may not be your normal major religions like Methodism or Baptist or something like that. It could be something you've never heard of before. And you can ask for an explanation and documentation, but I can tell you what, and I'm going to go through the steps that you can go through to evaluate. I mean, but I will tell you that I would be very uncomfortable to tell a client of mine to deny an accommodation because the person doesn't have a sincerely held religious belief. I mean, it would have to be, I would almost have to see a gross fabrication, like a situation where an employee came in and asked for an accommodation for a disability, rejected it, and said, yeah, now I've adopted the religion of the fuzzy sponge monster, my own religion that I've created, and now I want the same accommodation you just denied because when I tried to claim a disability. It would almost have to be that shocking to me before I would feel comfortable say you could deny an accommodation for religious belief. Delving into people's religious beliefs is is a risky legal process, okay? Again, but you can ask for an explanation and documentation, and there's even an analysis, there's even factors you can consider to determine whether or not a person has a sincerely held religious belief. Has the employee acted inconsistently with that professed religious belief? And I'm not going to give you examples. Whether the accommodation sought is particularly a desirable benefit. Maybe they come in and say, hey, I have some sort of religious belief and I want some benefit that everyone wants. And the timing of the request. And I gave an example earlier where someone requests an accommodation for a disability, they're denied, and suddenly they just jump to a religion they adopted yesterday. That would be very suspicious, very, very suspicious. And there might be other reasons that you might have doubts about the religious belief. Again, go through the analysis. I would be very concerned about denying an accommodation, challenging someone's sincerely held belief. Courts have found undue hardship in this context where the religious accommodation would impair workplace safety, would diminish efficiency in other jobs, and would cause coworkers to carry the accommodated employee's share of potentially hazardous or burdensome work. Those are some examples of where the courts have upheld the denial of an accommodation. Okay, what are some other relevant factors concerning the undue hardship considerations? They would include the proportion of the employees in the workplace who have already been fully or partially vaccinated, the extent to which the employee has contact with non-employees, and the burden on the conduct of the employer's business, and the risk of the spread to the public, whether the employee works in a solitary or a group setting. You know, is this person doing telework, or are they a customer-facing people? Could be a relevant factor. In the number of employees who are seeking similar accommodations, is this going to be very burdensome? If we have to accommodate 20 or 30 people, that would be a pertinent consideration. Proof of vaccinations. Okay, checking my time. A covered contractors must require covered employees to show or provide one or more of the following documents: a copy of the record of the immunization, copy of the vaccination record. Mine was on a little blue card. A copy of immunizations from a public health. Other official documentation having the vaccine name, date of administration, the name of the healthcare professional administering the vaccine. I do believe that would cover an actual medical record if it had that information on it. You will notice that what we do not see on the sheet of paper is an attestation from the employee. You may recall earlier in the short outline on ETS that under the OSHA had contemplated the ability of the employer to rely upon a specific attestation. I do not see a similar provision dealing with this executive order. Okay. Timeline. Okay, we're getting what is the timeline? Since there is currently no case here, under the timeline, again, if you're subject to this provision and subject to the order, you must receive the last dose by January 4, 2022. That would either be there if it's the last dose of the primary vaccine. And that's because the actual deadline is 2 weeks after the 4th. That's the 18th, right? Yeah, 18th. Because the timing of the vaccine administration depends on the manufacturer, you really have to make sure that there's stuff happening before January the 4th. And I've given you the dates there. I mean, we're getting pretty close on some of these, on the Moderna inoculation. Any questions on that? I mean, it's there on the screen before you on the deadlines. Enforcement. Now, under the OSHA ETS, it was pretty clear that, of course, the enforcing agency was OSHA. OSHA enforces the Occupational Safety Act. But who is going to be enforcing this executive order? it appears to me, there's very little guidance, and this was one of the first questions I had when I began preparing for this seminar. Who is going to be enforcing these mandates? Because, for example, in the federal level, I keep talking about affirmative action plans, but there's actually a division of the Department of Labor called the Office of Contract Compliance that actually enforces affirmative action violations. So my immediate question would be, we've got this order that is mandating various executive agencies to include these provisions in their contracts. Who's going to be enforcing this? Is it going to be a single agency? Is it going to be the executive agency is it going to be the executive agency that is the contracting agency? Because most of these executive agencies, if not all of them, have their own enforcement wing there. It appears to me that it's going to be the contracting agency. And again, you heard me say it appears to me that it's going to be the contracting agency that is going to be responsible for compliance with the mandate. And it is likely that a federal contractor or subcontractor that fails to ensure compliance could be found to be in breach of the contract. Non-compliance could ultimately result in termination of the contract. Now, I haven't dug into it a lot, but I would assume that debarment, which is a technical term for you contractors, could be another possibility for a contractor that does not comply. So where a covered contractors are working in good faith and encounter challenges with compliance with COVID-19 workplace safety protocols, the agency contracting officer should work with them to address these challenges. But if the covered contractor is not taking steps to comply, significant actions such as termination of the contract should be taken place. And that is in quotes, and I gave you the site for that. I do not need to cover this with you because I covered this with you at the beginning of this outline, at the very beginning of the seminar. Again, let me go back. There may be some people that are online that did not see the beginning of this where I talked about litigation. There are a number of pieces of litigation dealing with this executive order, but unlike the OSHA, the temporary standard, I am not aware of any current litigation dealing with the executive order that addresses the state of Missouri as of 9 a.m. yesterday. That is all I have. I know I finished about 20 minutes early, but I will open it up to questions. And again, I will do the best I can to answer your questions if you have questions. But why don't we begin with the audience first? Let me get my contractor.
And Daniel, we had a few questions come in online. Do you mind if we read those to you?
Can I see them here? You can read them to me. Go ahead.
So the first person is asking if they can get a copy of the slide deck when the presentation is finished. Is that okay with you if we
Yeah,
email that out?
contact Chase. Yep. That's an E. I can handle that question. Yeah.
Okay. And the next one,
get a hard
what if an
one.
employee got the first shot and did not get the second shot for 10 months? Are they fully vaccinated?
No, I say that again.
So an employee received their first shot and then did not get the second shot until 10 months later. Are they considered fully
Okay.
vaccinated?
I would want to confirm that, but I don't think so. I believe that the regulations for fully vaccinated, that there's a period of time, and it may even be like 17 days. It may be that specific. I'm thinking, I really don't think so. Because I think you have to strictly follow, there's a strict time period between those doses. You have to take them to be fully vaccinated. I'm almost positive.
Okay, and the third online question, do you have any guidelines for hiring new employees? i.e., once a new employee is hired, do they have a timeline to provide proof of vaccination or to be vaccinated?
Well, I think they would need to have proof that they're fully vaccinated. If you're under a contract and you're past the 18th date, you would need to have proof of full vaccination. Next question. Okay.
So if you have a remote employee who never sets foot on your physical agency, how can they demand that that person is vaccinated when there's no safety risk
I don't know
to
what
the
to
other
tell you,
employees?
but you saw the slide.
Yeah.
Um,
And is that being contested in court at all?
You know, I've not reviewed the specific cases like the one I mentioned earlier that impacted Kentucky, Ohio, and Tennessee. I mean, we can agree that's kind of ridiculous, isn't it? Right. But I don't know what else to say. That's the way I read the order in the task force guidance. It would seem to me that the OSHA ETS had a much more reasoned approach to that situation. Any other questions? Now, I would think that in that situation with the remote worker, and they came up with a disability, or suddenly they joined the purple monster religion or something, that maybe you could explore telework as an accommodation. I don't know. I know. I didn't say this made sense, okay? A lot of it. I'm just, don't shoot the messenger here. Okay.
So with the executive order, there's no number of employees limits. It's just any entity that has a covered contract.
That's the way I construe it. I mean, we went over the limitations at the beginning, number and products and all that.
And then does the same apply to if you're functioning as like a joint venture? Do both parties,
Say that again.
if you're functioning as a joint venture, then does it apply to both parties or whatever? However many
So you
parties?
threw in a very technical term called joint venture that is causing me concern to answer that question out of hand. I think that I can already tell you need a very detailed factual discussion with someone on that particular scenario.
Gotcha. Okay, thank you.
Okay. Any other questions?
Does the federal contractor have to notify the supplier of the vaccine requirement to complete work on their job site?
I don't know how to answer that question. So you've got a contractor and you've got a supplier.
So the question is, does the federal contractor have to notify the supplier of the vaccine requirement in order to complete work on their job site?
And the difficulty I'm having with that question is the word supplier, one would assume means only providing products. And as we mentioned earlier, providing only products was one of the exceptions where for a subcontractor that they do not have to be subject to the mandate. So assuming that the supplier does provide some services, then they would already be notified of that because their subcontractor is going to have the clause. Do you follow me? That's the struggle that I have. The question presupposes that we've already made a conclusion on whether or not the subcontractor is dealing with services or products. So I think that would need more information to answer that question. Do you see the issue, everyone? Okay. Next question.
So if you allow a religious exemption for the purple monster, whatever, and then other employees find out that you've accepted the purple monster and they start coming forward after you've set the deadline.
You're gonna start a religious movement right there in
Yes.
the workplace.
So I guess
right
if you
there.
send out a thing saying like all exemptions are due by January 1st, and then on January 2nd, somebody comes and says, I joined the club, what do you do?
You know, how do I deal with that? You will have to go through the interactive process and deal with each one and go through the analysis. Could be, yeah. Yeah, well, that was one of the factors, if you had multiple, you could consider the sheer number of requests for accommodation in the undue hardship analysis. And do remember with religion, there is a different undue hardship standard. It's easier to make. I'm not going to go into detail why. It has to do with the First Amendment and all that. But
I had a question about the vaccine cards and the information required. I know mine and my family's, we all have lot numbers for each vaccine that was received. And I didn't know if they were all that way because at one time there was talk about a lot of people falsifying those vaccination records. So I just wondered if it wasn't on the slide. So I just wondered if there was any requirement related to that.
I don't know. I'd have to look into it. Anything else? All right, I know this has been I know this has been so exciting for you all. And I did the best I could to make it exciting, but good luck out there. And you'll probably go back and you'll see news today that there's been some injunction making everything I just told you totally and utterly irrelevant. But thank you very much for your attendance.
Thank you all so much for attending. As you guys know, Connell Insurance, we hold 3 very large seminars down in Branson with about 300 attendees plus. We will do these throughout the year on either upcoming legislative topics, HR and risk management in Springfield, Branson, and across the state. So thank you all for attending. Please do not forget to fill out those evaluation forms for the Missouri SBDC. We have a box right here you can drop it off at. And thank you guys again for being out here. We hope you enjoy your wonderful 70-degree December 2nd weather today. Have a good one.